minutes to see if more people are showing up.
We got 14.
We have 14 people.
It's,
There George goes practicing accounting without a license again.
what?
George is counting the number of attendees.
I can't, well, it looks like it says there are 18 and
Yeah, we got 18, George.
I can only see 6 people on my
Try again,
screen.
buddy.
What?
I'm saying, George, try again. It looks like 18, man.
All right, well, if we have 18 people, we can get started. We've got 2 superb speakers with us tonight. One is Professor Bill Hing, who is teaching immigration law at USF. He's also taught at UC Davis, at Golden Gate, and I probably left another law school out.
You left out Stanford just because you went to Cal.
Oh, that's right. I forgot
That was a good
school.
call.
And you are in charge of an immigration law, I want to say clinic, but you'll correct me on that if I got that wrong. That's very well known for this work. You're a leader in the Bay Area, if not the whole country. And you were brought to us by our Hellenic Law Society member, David Bigaleison, who has recently retired from the practice of law after a 50-year career, mostly in criminal defense. And he regularly did criminal defense of the issues that are raised here. And it's mainly we wanted you guys to educate us on the immigration law and constitutional law issues raised by the ICE actions in Minnesota, Chicago, and California, and other places. So without further ado, David and Bill, please take it away.
Bill, we spoke about this about a week and a half ago, and I want to talk about some Fourth Amendment issues, that is, search and seizure. I want to talk about some Fifth Amendment issues, that is, the right to remain silent, and some due process issues. And then I want to talk about some Eighth Amendment issues, and that is the right to reasonable bail. Uh, shall we start with some Fourth Amendment issues and talk about, begin by talking about the seizure of the person?
Sure. In the immigration context, it's been long established by the Supreme Court in a case called Brignone Ponce back in the 1970s that in order for immigration officials to stop a person and question them, immigration officials must have reasonable suspicion that the person's a non-citizen. And that case, Brignone Ponce, involved a situation near the border in Southern California where the Border Patrol officials admitted that they stopped someone purely because they were Mexican looking. And that case, that they stood by that, the immigration officials stood by that. And that case went to the Supreme Court, and the Supreme Court did a good and bad thing in that case. The good thing that they did was they held that immigration officials cannot stop someone simply because of their appearance. They can't stop someone simply because of their appearance. That's the good part. And so they threw out the case against, it was a criminal case, actually. They threw out that case. But the Supreme Court went on to say, however, if there are other factors, then taking the totality of the circumstances, whatever those factors are, we'll leave for another day. And maybe with other factors, immigration officials might be able to reasonably say that someone is a non-citizen. But the basic holding is that racial profiling alone is not adequate to conclude there's reasonable suspicion that the person's a non-citizen.
Bill, let me digress for a moment and go to the criminal law standard and then come back to reasonable suspicion. Under criminal law, the authorities have to have what we call probable cause to stop someone and restrict their liberty to come and go. And the probable cause has to be specific and articulable. That means specific to a particular crime and also something that they can articulate clearly. Reasonable suspicion is a lower standard. Um, can you tell us what reasonable suspicion consists of, or has that remained undefined?
No, there's been a fuller definition. There have been fuller examples since then. And reasonable suspicion has been deemed to have been met if, based on, for example, the experience of the immigration officer, that the kind of clothes that somebody wears, the location of where the individual is, um, the type, even the type of vehicle that the person's in, that those types of factors in different forms have been allowed to add to the totality of the circumstances to become reasonable suspicion. So it's difficult for me to say, well, here's what's going to happen in every case, because the location of the action also makes a difference. For example, the Ninth Circuit, which those of us who live in California or here in the West, we're all in, right? The Ninth Circuit has two different decisions, one holding that there's reasonable suspicion, one holding that there's not reasonable suspicion in two different parts of the Ninth Circuit. One took place in Los Angeles years ago, and another one took place in a small town called Havre, Montana, Havre. And the facts in both those cases were very similar. It was somebody who was Hispanic looking, was speaking Spanish, was working at a particular construction site. The facts were very, very similar. And the court held that in the Los Angeles situation, that was not reasonable suspicion because there's so many Hispanic, Latino folks in the Los Angeles area. But the court held that it was reasonable suspicion in Havre, Montana, and that case was about 10, 12 years ago, because at that time, there were not that many Latinos in Havre, Montana. And so the Ninth Circuit held that was reasonable suspicion.
So that means that it's legal to be Hispanic looking in Los Angeles, but illegal to look Hispanic in Havre, Montana.
That's one way of putting it.
Okay. And now, what does that mean in terms of people's everyday lives as they go out there about their business? How do the ICE people distinguish between people who are lawfully within the country, either because they're United States citizens or because they are lawful residents, and those who are here without documentation under these circumstances?
Okay, so we're talking about two different things here. One, we're talking about whether or not there's reasonable suspicion that the person's a non-citizen.
Hmm.
And you're also raising the issue, how do they know when that non-citizen is undocumented or deportable? Okay.
Yes.
So if somebody has a green card, a lawful permanent resident, um, that they can still be stopped, okay, if
Hmm.
they're a non-citizen. Uh, so that's one thing that we should keep in mind. But what you raise is a great point, which is they cannot tell. ICE cannot tell whether or not somebody's, in my opinion, ICE cannot tell if somebody's undocumented or is deportable by just looking at them. They cannot tell if they're undocumented or deportable if they're speaking Spanish or if they're working at a construction site or if they're at a Home Depot parking lot. They cannot, they do not know. There's no way they know that. But what what happens is that we have the luxury. We're sitting here talking the law. And the problem is most people who are stopped by ICE, they don't they don't know the law, they don't know their rights. And so when they get stopped by an ICE agent and they're asked, 99% of the time, if not more than 99%, they don't know their rights. And so they blurt out that they don't have documents or they assert that they're US citizens. And we have the luxury of reading cases and representing people that we know the facts, but what we see as lawyers and representatives is just such a tiny bit of what happens. We don't see what happens in the vast majority of encounters. And the vast majority of encounters, ICE just gets away with racial profiling. And uh, eventually they'll let a citizen go, although they have deported citizens, okay? Um, and if it turns out the person's undocumented, well, they just take them in and the person doesn't have the wherewithal to make a motion to suppress.
That then leads me to, by the way, I want to interrupt and say, Bill and I invite all of you to interrupt with questions. Just raise your hand. Um, anyway, that then leads me to the Fifth Amendment, and that is, of course, we know that when a person is in custody, the Fifth Amendment attaches, and when the person is in custody, the authorities have to give the Miranda warning, which we all know. Um, and so one of the issues is when is the person in custody? And the short definition is when they're not free to leave. Now, can you give us some examples about how that comes up in reality and then what it looks like when you go to court?
Yeah, that's also such a good question. Um, so back in the 1980s, uh, I those of you who are lawyers, I'll 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 put the citation in the chat box later. Um, the Supreme Court decided this unbelievable case. Okay, it's the Sandoval case, where immigration officials go to a workplace. They station themselves, agents station themselves at the exits. Okay, they're armed. The agents are armed, and they station themselves at the exit. And other agents go into the workplace and start asking people questions. They start asking people for their immigration documents. That case goes up to the Supreme Court. And the Supreme Court held that that was not a detention. And because the Supreme Court was living in fairyland, and they said, well, nobody said that they couldn't leave. It's true that they were armed agents at the door, and the armed agents were walking through the workplace asking people questions. But the people could have got up and left quietly. No one said that they couldn't do that. Incidentally, I drop a huge footnote here because it is because of that decision that when we do our Know Your Rights trainings, we inform people that if ICE comes to the workplace or to your home, well, let me stick to the workplace for a moment. If ICE comes to your workplace and they don't have a warrant, because that case did not involve a warrant, you can remain silent. And I know we're going to get to that, David. But you can also get up quietly and walk away because the Supreme Court has held that that was not a seizure. And so as unbelievable as that may sound, that's why we do Know Your Rights trainings. That's part of why we advise people to quietly, calmly get up and walk. And for sure, don't answer any questions. They don't have to get up and leave. They can still just sit there and not answer questions. And so basically, it's not a seizure unless you try to get up and they don't let you go.
And of course, there's the United States Supreme Court decision that says that the Fifth Amendment has to be invoked, that you can't just sit there and keep your mouth shut, that you actually have to say, I want to remain silent. I don't want to talk to you. It doesn't have to be in those specific words, but it has to clearly invoke the Fifth Amendment.
Right. Yeah, and that's why we also hand out red cards that many people have seen. The Immigrant Legal Resource Center, which is one of the organizations that Peter was alluding to that I founded in 1979, distributes red cards in 30 some languages. And if you're afraid to say it with your own words, you can hand it to an immigration agent and it says, I don't want to talk to you. I'm asserting my right to remain silent.
By the way, Bill, I want to give you a shout out to all the people here about the Immigrant Legal Resource Center. This is something that Bill founded, and it's something that people go to often as a first stop when they have clients who have immigration problems, and the lawyers want to get oriented as to what they need to do, where they need to begin in order to make sure that their clients get the help that they need.
Right. And I had the adventure of also 10 years ago starting an immigration clinic at USF. And that clinic is a little legal aid office. We have over 400 clients there, and those are mostly Central Americans applying for asylum.
What's going on with asylum cases now?
Wow. You know, the Trump administration's goal is to end asylum as we ever knew it. Okay. Here's the evidence of that. One big one locally is that they've fired, they fired of the 20 immigration judges that were in San Francisco. This has been in local headlines recently. They fired 18 of them, 2 are left, and they physically have closed where the court at 100 Montgomery Street. The last day was last Friday, as a matter of fact. And all the cases are being transferred to an immigration court in Concord. That logistically very difficult to get to. The reason I'm pointing that out is the people that they fired were the immigration judges that were more inclined to grant asylum. They were more fair. So that's one thing they've done is they're across the country. They fired 100 immigration judges, and the ones they fired are the ones that have a higher than average approval rate. The other thing they've done, of course, is they've closed the border. The other thing they've done is they've made motions to send people to third countries. If they're claiming asylum from Honduras, well, you know what? We're going to deport you to Uganda or to Paraguay or to Libya, where they've agreed that they'll entertain your asylum application. So then they've also interpreted asylum law. The Board of Immigration Appeals, which is under control of the Attorney General, they've interpreted asylum laws. Just in the last year, last 17 months, they've they've abandoned prior precedent and made rulings that make it very difficult to get asylum. What has happened to asylum, David, is that um, it's I don't want to say it's dying, it's under attack. And our hope, and I'm not sure how long this is going to last, our hope is in the Court of Appeals, because you can appeal those denials directly from the Board of Immigration Appeals, where we live, to the Ninth Circuit. And we're fortunately that Ninth Circuit case law on asylum is pretty good. Ninth Circuit, Second Circuit, Seventh Circuit isn't bad, Third Circuit isn't bad, but there are other circuits that are just as bad as the Board of Immigration Appeals, the Fifth Circuit, for example, um, and the 11th Circuit, and so it's a shame, because asylum is part of our refugee responsibility, and um, it's something that the Trump administration started attacking during Trump 1, and they came well armed during Trump 2 with so many more ideas and strategies to end asylum.
Bill, I have a question. Isn't there a statute that says if you have a reasonable fear of persecution due to your religion, your race, your political party, and it's part of the United Nations mandate that they can't that they have to grant asylum, not just that they can, but if you prove that.
Yeah, okay. So the statute, you're right, we're part of we didn't sign on to the 1951 convention, but we signed on to the 1967 protocol on refugees and asylum. So we are bound internationally by these standards. And you're right, if you have a well-founded fear of persecution based on race, religion, nationality, political opinion, membership in a particular social group, you should be granted asylum. And that the Supreme Court case that interpreted that is very, very generous. It's one of my cases, INS versus Cardoso Fonseca in the 1980s. The Supreme Court held, and it was a decision written by Justice Stevens, 6-3 opinion that included Scalia, that that even a 10% chance of persecution is sufficient to establish a well-founded fear of persecution. You would think that, hey, we should be granted asylum all the time. The Board of Immigration Appeals for many years has found their way around that by attacking credibility, for example, by narrowing what a political opinion is, by saying that membership in a particular social group is not meant to cover, for example, domestic violence or gang violence, which today, that's a lot of the folks that are fleeing. So that's one thing. You use language, Peter, involving suggesting that it's mandatory to grant asylum. It's not, okay? So there's actually 3 different kinds of relief that are relevant. One is asylum, and the way the statute is read, asylum is actually discretionary. It's not mandatory. The word that it's used for asylum is the Attorney General may grant asylum if the standard is met. However, there's another provision called withholding of removal, which is very similar. That is mandatory, that if you meet the standard, but that standard is higher, that's preponderance. It's not 10%. Preponderance has got to be more than likely that you're going to be persecuted. That is mandatory. And it's a good question, because there are some people that we lose on asylum for some reason, but we meet the withholding standard and it's mandatory. So they get withholding protection. And I'm trying not to get too much in the weeds here, but the big difference is that if you get granted asylum, you can get a green card. If you get granted withholding, you just get a piece of paper that you can't be deported. Okay. And so there's a big qualitative difference. And the other thing is that a lot of people, for asylum, you have to meet a 1 year deadline. If you haven't applied within 1 year, you can't apply. And so that's another reason why a lot of people don't get granted asylum is they miss the 1 year deadline.
This is Jim Fatinas. Question: jurisdiction. So, the immigration system is they're Article One courts, right? Or what? Whereas, if it's if these are statutes and we're party to treaties, why wouldn't Article Three courts resolve these disputes?
Um, we we can get into the Article 3 courts after the BIA decides against us. Then you get to file a petition for review in the Ninth Circuit, which is Article 3, of course. But the review is narrow. When it comes to discretionary decisions, the statute is written that the Court of Appeals does not have ability to review discretionary decisions. If it's a question of law, then the Court of Appeals can review. And so sometimes there's a fine line, but that's a problem. But you raise a much more interesting question, Jim. Why, who are immigration judges and who is the Board of Immigration Appeals? They are administrative. They're not even they're administrative agencies. Who is their boss? Their boss is the Attorney General of the United States. Okay. And so, as mind-boggling as this may sound, two things. One, if the Attorney General does not like a precedent decision that's been rendered by the Board of Immigration Appeals, the Attorney General can himself or herself reverse a BIA decision and establish his or her own precedent for asylum or whatever relief. And so that happens all the time. The other thing is that if they don't like the employees, and I alluded to this, they can just fire them because they are the employees of the Department of Justice. And so they're being challenged. I mean, there's a couple of lawsuits that have been filed because they're civil service employees, but Trump is asserting this unitary executive authority theory that some of you may be familiar with. It's what they used to defend what Doge was doing under Elon Musk. Their claim is that because Trump is the executive, he can fire anyone he wants to who works for the executive branch. So Jim, there's long been an effort, unsuccessful, of establishing an Article 1 immigration court, much like the bankruptcy court, which is a separate Article 1 court, right? And the tax court is a separate Article 1. They're not Article, but they're independent of the agency. And Zoe Lofgren, for example, she introduced legislation to do that a couple of years ago, but it got nowhere.
Is there any international body that has jurisdiction
No.
over? No.
No, I mean,
have another question
yeah.
more broadly on stopping of a person walking down the street, independent of immigration authority, but just a police officer comes up to somebody and says, "Can I see your driver's license? Can I look in the trunk of your car?" If the person acquiesces, they can do that. But if the person says, "No, I don't want to show you my driver's license," isn't there a case on that, Bill or David, that you don't have to show them your driver's license?
That's the Lawson case, and it goes back to the late 1970s. Mr. Lawson was living in La Jolla, California. He happened to be black, and he liked to walk around La Jolla at nighttime. And if any of you have ever been to La Jolla, you know that it's against the law to be black in La Jolla, and especially against the law to walk around La Jolla when you're black. So the cop stopped him and he said, "Provide me with identification." Mr. Lawson's a bright guy. He said, "No, I'm not going to give you any identification." And the case, Mr. Lawson represented himself up until he got to the United States Supreme Court. When he got to the United States Supreme Court, the Supreme Court said the rules of the Supreme Court do not allow you to appear pro se, and they appointed Jerry Falk to represent him. And the United States Supreme Court said this law requiring reasonable identification is vague, and therefore we're striking it down. You can't do that. That's the Lawson case. And so, no, you don't have to give them uh, ID. And if they want to take you into custody, if they want to restrict your liberty, they still have to have probable cause, which has to be reasonable and articulable, except in the eyes of Justice Kavanaugh. And Bill, I know you've been waiting for me to introduce that most recent opinion by Justice Kavanaugh. Why don't you give us the background of how the case came up first, and then you can tell us what this guy had to say about it.
Thank you for that question, David, and you're right. If there's one thing that I want folks to walk away from this evening, it's that Kavanaugh has pretty much licensed racial profiling when it comes to immigration. So almost a year ago, in early June, some of you may remember, because it's in the news, there were some 1,700 National Guard and ICE agents that were imposed on Los Angeles and the Los Angeles greater Los Angeles area, and basically they just started going up and down sweeps. These were ICE sweeps, the kinds of ICE sweeps that Trump promised and that Stephen Miller promised, that they were just going to deport 1 million people. And this was a manifestation of that promise. They just went up and down. You can Google these arrests at car washes, at Home Depot parking lots, at construction sites. And people were getting beat up. People were just grabbed because of what they looked like or because they were speaking Spanish. And immediately there was a lawsuit filed challenging these sweeps in Southern California. And again, we probably won't have a chance to talk about it. This was what was in essence duplicated in Minneapolis several months later, of course, which really hit the headlines when 2 people were murdered by ICE in Minneapolis. But Los Angeles was where this happened first. And so there's a lawsuit that's filed, and they drew a judge, a federal district court judge in the Central District, which is Los Angeles, and her name is Frimprong, Frimprong. And she's it's interesting. She's of African descent. Okay, she's of African descent, and her full name is Mami Uwasi Minash Frimpong. And she ruled against the Trump administration on this. I'm sure that they hated this. Okay, they hated the fact that there's a woman who's of African descent ruling on these serious constitutional issues. I'm just sure that they hated the fact that of who the judge was. You can read her, you can find her decision to issue a temporary restraining order, and it's a case called Verdugo Perdomo versus Noem. Verdugo Perdomo versus Noem. And my gosh, it's a long decision about how they were going after people that were street vendors at car washes, at parks, at gyms, at churches, at swap meets, at packing houses, at farmers markets. They just went to all these places, and in just a little bit over a month, more than 1,500 people were arrested in the Los Angeles area and aggressively. And she also talked about US citizens that were stopped and held for hours before they were let go. So, so she issues a restraining order citing the Brignone Pons case that, hey, you can't stop people just because of what they look or sound like, and these other things that you're doing, which is stopping people just because they speak Spanish, that just doesn't cut it. Okay, that doesn't prove that they're a non-citizen just because they're Hispanic looking and they're speaking Spanish. That's not enough evidence to have reasonable suspicion that the person's a non-citizen. Because after all, we're in Los Angeles, okay? Well, the administration didn't like it. And even though they did file an appeal with the Ninth Circuit, they also went to the shadow docket of the Supreme Court. And so for the non-lawyers on this call, there is something called the emergency docket that the Supreme Court has. And if there's a dire emergency, you can bypass, at least temporarily, you can bypass normal appellate procedures, which can take time. It takes briefing, it takes oral argument, and you can go to the Supreme Court and say, we need you to intervene right away. And the reason why lawyers call it the shadow docket is because unlike normal Supreme Court cases where you get to listen to the oral arguments, you get to access the briefs, you get to hear the discussion that the judges have with the appellate attorneys. When they accept a case on the shadow docket, they're not even obligated to write a written decision. So you don't know why they've made a decision a certain way. So the Trump administration has been a master of this, and they've used the shadow docket in many other immigration cases. And this was one of them. And they got the Supreme Court on a 6-3 opinion to throw out Judge Frimprong's temporary restraining order. And they just issued a 2-sentence thing saying the temporary restraining order is set aside pending appeal to the Ninth Circuit, period. But Justice Kavanaugh decided that he was going to write a concurrence anyway, okay? And in response to Justice Kavanaugh's concurrence, there's a dissent by Justice Sotomayor. And it's a 7-page concurrence where he explains why he voted the way he did to throw out the temporary restraining order. Now, he's not claiming to write for the other 5 justices, unlike Sotomayor, who was writing for Justice Ketanji Jackson and also Elena Kagan. Kavanaugh didn't claim that he was writing for the other 5 conservatives, but you can assume that, well, maybe you can't, that some of what he's writing is consistent with what the other is thinking. Long and short of it, he, without any citation, he said, well, after all, there's 10% of the population in Los Angeles is undocumented. And also, we know that illegal immigration is a big problem in the United States. And so he said, given that background, that it's fine, that it's fine to stop and question people if they're speaking Spanish or speaking English with an accent, okay? And if they're at the following places, if they're at Home Depot parking lots, if they're at construction sites, if they're at our low-wage worker locations. And the puzzle to me is that another factor that he listed, where if they're speaking Spanish or if they're speaking English with an accent, he also said, or if they're at a bus stop, that can be reasonable suspicion. And he didn't even define what kind of bus stop. He just said bus stop. And so one of the early questioners said, well, what happens now when they walk up? What do people do? Well, it is true that even before the decision, but after this decision, there are so many people that are afraid to go out on the street. They're afraid to go to their medical appointments. They're afraid to take their children to school. And we all know that because we've heard some great stories about neighbors and friends organizing to protect the pathway for people to go to walk their kids to school. But people are afraid to go to school now or to go out. And it's because of Kavanaugh's decision. And that's where we have it right now, that people are constantly looking over their backs. And like I said, we saw another manifestation of this in Minneapolis. We've seen it in Portland. We've seen it to a degree in Chicago. Mayor Lurie will have you believe that he stopped this from happening in San Francisco back in October because he called up Donald Trump and prevailed on him to not escalate ICE presence. Again, first of all, ICE is here. ICE is making arrests every day in the Bay Area. Now, they're not doing the kind of sweeps that happen in LA. That's true. And for whatever reason, Trump did threaten in October to send thousands of agents and National Guard to San Francisco, and he didn't do it. And Mayor Lurie acknowledged that that it wasn't just he that called, right? It was also
NVIDIA.
yeah, exactly. The guy who just went to China with Trump, right? The Chinese American, Jason Wang, is that his name? He called up Trump. He's there in China with Trump right now, but also Mark Benioff called Trump. And so I guess money talks because they didn't escalate ICE presence in San Francisco because of that, David.
Let's go back to another Fourth Amendment issue, and it's what I call the knock on the door, and the ICE people entering people's homes. What does the Fourth Amendment say about that, and how does that actuate itself in reality?
They, first of all, they go to people's homes based on many different factors. One, they do have lists of folks that have been ordered deported for not showing up at their hearings or for other reasons, lost their appeals. They have those lists and their addresses. And so that's one basis for going to knock on a door. There are also times where they go someplace because a neighbor calls, okay, and says, I think the person next door to me is undocumented. Now, does that happen often? Not that often, but it does happen. And the reason why it doesn't happen that often is because they've got plenty of people on their list already who are deportable. But let's assume that they do have the name and address of somebody who's deportable. They'll go and knock on the door, and they are hoping that the person who answers the door just lets them in. The truth is, and you know this, David, you don't have to let anyone into your home if they don't have a warrant, a search warrant. And so ICE is lazy. ICE knows how to get a warrant. They've got to go to federal district court and get a federal magistrate judge or a federal judge to sign a warrant. They can do that. For those people that are on the list, that's all they need to do is to go to federal court. They're lazy. They don't do that because they don't need it. They feel that no one's ever going to challenge them. And so again, that's why we do these Know Your Rights trainings. If somebody knocks on your door, ask for identification and ask for a warrant if they claim to be ICE agents. And so this does work, incidentally. This works as recently as 6 months ago. We trained an apartment building in Redwood City, and ICE went to that apartment building, and everybody in that building had red cards, and they told people that didn't want to talk, and they didn't give permission to come in. And after about 20 minutes, ICE went away.
That's wonderful. Um, how about if we talk about the Eighth Amendment, um, the right to reasonable bail? The government's been locking people up um, and denying them bail. What's the foundation of that, at least in the eyes of the government?
You know, and this is going to lead to a big compliment that I have for non-immigration lawyers in the Bay Area and in other parts of the country who are helping to step up on habeas situations. So the position of ICE, so as long as I've been practicing immigration law, it's been over 50 years. Um, when they arrest somebody who's not a criminal, hasn't been convicted of a crime, people are eligible for bond. And immigration, you go to bond hearings and you address the two issues of whether or not the person is a danger to the community or whether or not they're likely to abscond. That's always been the standard for bond. And immigration judges, some are more reasonable than others, but at least you had a shot at bond. Well, the Board of Immigration Appeals has now held that no, immigration judges actually don't have authority to grant bond, even for people who have been here a long time. If the person's undocumented and is deportable because they don't have documents or they've been convicted of a crime, even if they presented themselves at the border, which most of our clients, they came to the border and asked, they didn't try to sneak in. They asked to talk to an immigration officer because they wanted to apply for asylum from Honduras or Guatemala or El Salvador. And so, but the position of the Board of Immigration Appeals in the last year and a half, there's a couple very controversial opinions. They've concluded that people don't have a right to bond unless the immigration agent wants to exercise discretion and let them have a bond hearing.
Isn't that an Article 3 question, not Article 1?
Well, that's what we're arguing. That's exactly what we're arguing.
Okay.
And that's why habeas has become a new tool that immigration attorneys now need. I'll be honest with you. Before the last 6 months, I hadn't done a habeas case for 20 years. Okay. Because I didn't need to, because our clients either were not in detention or we had a right to a bond hearing. Well, with so many people in the Bay Area who are getting arrested, walking into their courthouse, walking in for ICE check-ins and getting arrested, not to mention others who had old deportation orders, but they never got deported, and now they're coming after them because Cambodia didn't want to take them back. Vietnam didn't want to take them back. Laos didn't want to take them back. There's a large group of those guys that are deportable that those countries didn't want to take. Well, now they're being arrested and detained because Trump wants to send them to South Sudan or to Uganda. Well, those guys are waiting in detention, and most of them are in Kern County in Southern California. In California City is a gigantic new detention facility in Kern County. And so what's happened is that once people are detained, you're right, we're going into federal district court and saying, hey, these detentions are totally wrong. The interpretation of the Board of Immigration Appeals is incorrect. And so the good news is that the Ninth Circuit has held that the BIA's interpretation of law is incorrect. But the person doesn't automatically get out. We still have to prove that the detention is unreasonable, that the person's not dangerous and the person's not likely to abscond. And
Yeah,
they
but
do.
is that decided by the board or by the district court?
That's a very good point. Um, some of the federal district court judges are ordering immediate release. Other federal district court judges are saying, I'm not going to order release. I'm going to order a bond hearing by an immigration judge. And so we're getting 50-50 results here. And my clinic has now filed about 15 of those. And that's what we're getting. We're getting some federal judges ordering immediate release and other federal judges bouncing it to the immigration judge for a bond hearing. But at least we didn't have a bond hearing before, right? And so now we have a right to a bond hearing. Good
But
question.
is this only before the two remaining immigration judges?
No, it depends on where the person's from. And so we're representing people now in Los Angeles and
No.
San Diego, because we can do some of those virtually. But we physically went. This is how my students spent their spring break. Instead of going partying, my 10 students, we went to an ICE detention center in Kern County. That's what we did for a week.
That's wonderful. Is this under the Lake and Riley Act, or is it under some other precedent?
It's under just the board's interpretation of current law. The Lake and Riley Act, which was passed right at the end of Biden's tenure, it authorizes detention if somebody's just been arrested for even minor crimes. So it's related to somebody arrested for a crime. If somebody's been arrested for a crime, Lake and Riley allows ICE to take the person into detention. We actually haven't seen that happen much in the Bay Area. It's been used more in other parts of the country.
Yeah, I've seen some discussion on that on the National Association of Criminal Defense Lawyers website from, I believe, the First Circuit, where ICE has been detaining people under the Lake and Riley Act.
Yeah, right.
I have a question about some of the Minnesota occurrences, and starts with the case of this boy, Liam Conejo, and his father, who were, according to the press reports, the boy was coming home from school and they grabbed the boy and they tried to get the father to come out of the house. And I guess he eventually did. And the father had an active asylum case pending. And this is what the press is reporting about all over the place. People are showing up for their hearings. They have a pending case. The ICE people are in the hallways and they just grab them.
Yeah.
And aren't you entitled to have your case heard first before you're sent off to Texas and then another country?
Well, the good news is the ones where that happened in San Francisco, everyone who got arrested at the immigration court in San Francisco got released on habeas. There's 100% on those cases.
If you file the habeas.
If you file the habeas, but that meant that you needed an attorney to do it. Now, a lot of people are trying to do it pro se, but they don't honestly know what they're doing. And we've taken over some of the pro se ones. But yeah, you're right. But Minneapolis, San Diego, Houston, places like that where it's happening, those folks don't have the same result because there's been different approaches, there's been different interpretations. And so in that example that you're talking about, those folks got that man and his child got sent, as I recall, to Dilley, Texas, which is a family detention center in Texas. And the detainees there protested on their behalf, and they were eventually released. And I mean, the two murders in Minneapolis, I I want to. I know we're. I don't mind going over, but I do want to say something um, optimistic, uh, and I think that Minneapolis has it made a big difference. Okay, and it was because two people got murdered, right? Alex Preddy and I can't remember what her first name was. Good, Goode.
Renee Good.
Renee Good. They both, and there's film of that, and were awful, that totally unjustified murders, right? And finally, there's investigations of that, even though they didn't want to do that. Well, what happened as a result of those is people who weren't paying attention to ICE and what they were doing around the country finally paid attention. And it's everyone from your usual suspects, like lawyers uh, and immigrant rights advocates, all the way to musicians and artists and everyday people. And there's even social media influencers who came out of the work, people who they have websites on knitting or walking dogs or whatever, and they couldn't stand it. They said, I can't, I can't sit silent anymore, and I don't care if I lose half of my followers. I'm going to say that what ICE is doing is wrong, and this is why. And so, I really think that it's a pivotal moment, and it contributed to Kristi Noem being fired. It contributed to a little bit of shakeup in ICE. It's contributed to a little bit of pulling back. It's contributed. We can't believe everything we read, but it's contributed, I think, a little bit. It's diminished Stephen Miller's clout a little bit from what I've read, and so I really think here's my bold prediction. Okay, there's going to be such a backlash against Trump on ICE enforcement that we're going to see the pendulum swing completely in a different direction within the next few years, and we're going to see progressive immigration reform. I think that there's now plenty of good information, and more's coming, that long-time residents of the United States, irrespective of their status, they deserve something now. That people shouldn't be put in this position of not taking their kids to school, not being able to go to the hospital, not being able to go buy their groceries. That folks shouldn't live under those conditions, and we should do the right thing. And so that's my bold prediction, that there's going to be progressive immigration reform sooner rather than later.
We all hope you're right.
Before we leave, Professor, why don't you give us a pitch for your group and whether you accept volunteers, et cetera, because obviously you're doing very good work.
Well, thank you. I never turn away volunteers. We can train people, any attorneys out there, we can train people on habeas. Stephanie, who's on the call right now, has volunteered at some of our community weekend events where we provide free information to folks. And Stephanie knows this. I take volunteers that don't know anything about immigration law, and as long as you're able to nicely interview somebody, I'll put you to work. But also there's research to be done. For example, there's a group in Southern California that's working with Ukrainian refugees. Okay. And I shouldn't say refugees because they weren't granted full refugee status. They were granted temporary protected status and other humanitarian parole. They're very worried that Trump is not going to extend their stay. And so there's going to be need for advising Ukrainians on and it's not a few thousand. It's many, many thousand in the United States that are going to need help. So there's all different kinds of things. And And of course, we take donations. If you want to donate to the immigration clinic at USF, contact me. It's very easy to find me on the USF website.
Well, I want to make a pitch here, and that is if you decide to take on representing someone who's applying for political asylum, I promise you that it'll be extremely challenging. And to speak mildly, you're in for the thrill of a lifetime. These are very, very, very scary cases and require a huge amount of dedication, but they can be won.
Yeah. Yeah, the lawyers committee here in San Francisco, they still have an asylum pro bono program too, where they match you with an experienced attorney to mentor you. So the lawyers committee is good, and Central Legal, La Raza Central Legal, they also do habeas training, a lot of it as well.
Yeah, that's what I did through the lawyers committee.
Yeah.
Um, and it's really scary stuff.
This has been a very informative talk. On behalf of the Hellenic Law Society, I want to thank you, Bill and David. I still have one more question or follow-up. So somebody that's showing up at their hearing and is in the process of adjudicating their case, unless they have been arrested for something else, they should not be grabbed and taken out of the country. As a general if the law, we have rules of law in this country. If the law is, they ought to be able to adjudicate their claim, right?
Right. They have that lesson finally has been learned in Northern California. So they're not arresting people walking into the Concord court or the Sacramento immigration court. San Francisco court doesn't exist anymore. And so if they're walking in, they already have something filed, and they're walking in accordance with a notice that they received to show up, they don't get detained anymore. We're able to put a stop to that. Yeah.
So when people on this program and people who are on this program are acquainted with, that is, lawyers who are acquainted, that they're acquainted with, are confronted with the types of problems that we've been discussing, either directly because their own clients have come to them or because of things that they've learned through colleagues or just by word of mouth, whom do they turn to get some help and get these things started so that the people who are in trouble can get some help?
Okay, so in San Francisco, at the Bar Association of San Francisco, they have an immigration program that's called the Justice and Diversity Center. They actually have more than immigration, but the Justice and Diversity Center is the quarterback in San Francisco for representation. Okay, there are 15 agencies. My clinic is one of those 15 that gets funding from the city, and JDC distributes those cases. Okay, and so that's where to start. If it's somebody who's not in lives in San Francisco but lives in San Mateo or Alameda or Contra Costa County, they should also call their bar association. I don't advise calling rapid response for a non-emergency, but the local bar association usually knows who the pro bono immigration lawyers are.
And I also want to give, I want to interrupt. I also want to give a plug to JDC. I do a lot of volunteer work with JDC as a translator, and we do the special immigrant juvenile findings there. So definitely in San Francisco, the Bar Association and the Justice and Diversity Center is an excellent resource to start. And they also need volunteers. And they work with the several different clinics and organizations throughout San Francisco, as Bill mentioned. So definitely, if you're not plugged in there, definitely reach out to them or direct people who may need help to JDC.
I see a number of our members are on the call on the Zoom. If you have any questions, please don't be bashful before everyone leaves. Jimmy Dermitsis, Penelope, Monte, Nancy, you guys have questions. Let's hear them. You got to unmute yourself if you have a question. George, you have a question. Nick? Hillary, you didn't have a question.
That was a very interesting presentation. Yeah, I did an asylum case in law school. So, and I've been involved personally in a lot of immigration stuff in my personal life. So, very informative. Thank you.
Great presentation.
Thank you.
I have no questions, but very illuminating.
Shout out to, I have two nieces on here. They're sitting in, Dari and Jennifer. I've got a great volunteer and former student, Kenya. I got my sister-in-law, Gail. I brought on half the audience for you guys. Come on.
Yeah, that's all right. Nobody else is asking. I'm going to ask about the legal issue of the two bystanders who were shot and killed. And David probably is going to weigh in on some of this constitutional stuff, but one of them was just sitting in her car and supposedly swerved at the guy, and the other guy was tackled and he happened to have a gun on him. I mean, the facts are always messy things in these cases, but David, you're the constitutional law guru. Do you want to weigh in first, or Bill?
Well, the government's argument is that each of the people that we've been discussing had been interfering with ICE. And then that brings us down to the facts of the case and whether they were actually interfering with ICE or whether this was something where ICE started it and attacked them. And, you've got the government's version, but needless to say, the government isn't always right. And we're now faced with the problem of looking at the pieces after it's happened to adjudicate these things. As far as I'm aware, neither one of these cases has gotten very far in court. They're at the beginning stages in these situations. That's my awareness of it.
Yeah, awful situations, but I haven't kept track after the cases were filed. Yeah.
But this is a Fifth and 14th Amendment due process issue. You don't go executing people without due process.
Yeah, those have got to be the lead cases on this behavior, the ICE behavior.
Well, is the state of Minnesota looking to prosecute? I don't know if they ever announced what happened, because the federal government wouldn't let them have any of the evidence. And
the federal government is trying to interfere with that.
well,
Okay,
I'm going to
yeah.
thank you again on behalf
Sure.
of the Hellenic Law Society. What you're doing is righteous stuff, and we're very pleased that you took the time to tell us about these important issues. And I think we're going to call it a night.
Thank you very much.
Thank you to everyone.
Thank you, everyone.
Yeah.
Thanks,
Have a good
Bill
night.
and everybody.